Awesome. So just a quick disclaimer for this presentation. We are providing general information about alternatives to guardianships. It is not intended to be legal advice, and everyone's situation is different. So you may wish to speak with an attorney regarding your situation. And also the Disabilities Law Program does not assist with guardianship, but we do help with other decision-making options. So just a little overview of who Community Legal Aid is. So Community Legal Aid, or CLASI, is a private nonprofit law firm dedicated to equal justice for all. So we offer free civil legal services to assist clients in becoming self-sufficient and meeting basic needs. And we have 6 units. A few of them are listed, so it's not just the Disabilities Law Program. We have a variety of different units, and just for those who aren't familiar, the Disabilities Law Program itself is the protection and advocacy network for the state of Delaware.
Thanks, Jackie. So today, before we kind of launch into the explanation of what guardianship is and what alternatives are available, it's important to really understand kind of what's involved in this discussion. And we're talking about decision making, who has the ability to make decision making. Under the law, everyone over the age of 18 is assumed to have the ability to make their own decisions. So even someone with very profound disabilities, when they turn 18, the law assumes that they have the ability to make their own decisions unless something else is put into place. The ability to make different decisions, we look at what's called capacity. And capacity is really a legal term. It's about understanding to perform a legal task. A lot of times people think that capacity is kind of one size fits all, meaning you either have capacity or you don't for every task. And that's really not true when it comes to decision making. Capacity is specific for the task at hand. So the capacity to authorize a family member to have access to your health information is not going to be the same capacity as you need to be able to give all of your possessions to somebody else in a will. So it's really looking at the specific decisions that are involved and whether you understand them. A lot of times people think of capacity as a medical determination, and it's actually a legal determination with input from medical professional often. So that's just one common misconception, is that it's the doctor who ultimately decides, but oftentimes in terms of making a capacity determination, it is a legal determination. So again, capacity is the understanding and the ability to undertake a legal task. So capacity to enter into a contract, capacity to make a will, to give a gift, to consent to intimate relations. These are all different decision-making processes. And so the capacity to make that decision is going to be different for each one. It's going to involve weighing the understanding of what you're deciding to do with the risks of that course of action. Also, another important thing to understand about capacity is that it's not constant. You may have capacity one day and not capacity the next. There are many different kinds of medical conditions and disabilities where someone's capacity is going to change from time to time. So you may have a day where you can direct decisions yourself, and then another time where you cannot. And there are ways to plan for that with different decision-making documents. One thing we always like to stress when we give these presentations is that adults, including adults with disabilities, have the right to make bad decisions. And so we have to remember that's part of adulthood when we're thinking about a family member or yourself, in terms of whether you need somebody to make decisions for you or you need support. Just the fact that someone's going to potentially make a bad decision in and of itself is not necessarily a reason to take away their decision-making power. And for those of you that are not just past 18, if you reflect back to when you were 18, 19, 20 years old, I can almost guarantee you there are some decisions that you made looking back that you can say, you know, I'm glad that didn't turn out differently. That could have gone really badly for me. And that's part of the process of learning and growing and becoming more mature. So let's talk about adult guardianship. One really important thing to understand is that adult guardianships it's a legal process. It's not something that's automatic just because you were the guardian of someone under the age 18. I'm going to turn the slides over to Jackie to talk to you some more.
Awesome. So there are a few reasons why an individual might need a guardian. So, you know, there might be mental or physical incapacity, so they're unable to manage their property or care for themselves. There is a specific danger of them losing or not being able to properly manage their property or their persons. So that's when you think about when a person needs a guardian, those are kind of the things that we think about. So I guess breaking down guardianship a little bit more. So there are two categories of there are three now, categories of guardianship. So if a person lacks capacity to take care of their person, and when we talk about guardianship of the person, we're talking about life decisions. So basically an individual is kind of put back into kind of being a child. So they aren't able to make decisions for themselves. The individual who becomes the guardian makes medical decisions, enters into contracts on behalf of that individual. And certain decisions will require court approval before making them, but basically that's kind of what the guardianship of the person would be. So guardianship of the property would include all the financial aspects, so real estate and money. It doesn't affect the person, so it's very different. You wouldn't have the ability to make decisions on personal or medical care. Some people can have guardianship of both the person and the property, and there's also now guardianship, limited guardianship that is only for certain kinds of decisions or for limited purposes. Okay, so just a few technical details of the guardianship process. So it is a process that's filed through the Court of Chancery. And guardians have fiduciary duties, and they also have accounting duties that they have to report to the court. And because guardianship strips a person of their rights and privileges, the ward or the individual with a disability is afforded with a number of protections throughout the whole process.
Thanks, Jackie. So with the filing with the Court of Chancery, it is a court proceeding with a lot of different forms and paperwork that needs to be completed. The Court of Chancery does have a kind of a self-help guide on their website to help people who are not represented by attorneys with completing the paperwork. And the law library at the courthouse also has a lot of self-help materials for people who are doing it on their own. So it's not necessary to have an attorney to file a petition for legal guardianship over an adult, but certainly it's helpful if it is something that you can afford. But it is not a barrier. You're able to pursue guardianship even if you don't have an attorney. Another thing I wanted to mention, as Jackie pointed out, there are some reporting responsibilities which differ depending on whether or not you're the proper guardian of the property or person, or both. And as she mentioned, you have a fiduciary duty, which means that if you're not acting in the best interest of the person with a disability called a ward, there can be repercussions for you. One thing we always like to really highlight for families that are considering guardianship is that, as Jackie mentioned, there is an ability for the person who is the potential subject of the guardianship to have their own attorney. And so if the person with the disability isn't in agreement that they need a guardian, it can be really adversarial, meaning your loved one and you may be fighting in court, and it can get really personal and it can hurt a lot of feelings. So, that's something to consider when you're thinking about guardianship. It can be a really unpleasant process if everybody isn't on the same page about it going forward. There are procedures for emergency situations. So this is a question that comes up often. If there is some kind of significant concern about the person with the disability's safety, the potential guardian can file for an emergency or temporary guardianship, which can be put in place while the longer term guardianship is gone through the courts. So that's something to keep in mind if you are in an emergency situation. Another piece of information that's helpful is that there is an Office of the Public Guardian. So this is a government agency that will serve as guardian when there is not another appropriate person to serve that role. So an individual with a disability who maybe doesn't have any surviving family, or they're estranged from their surviving family due to past abuse, for example. That might be a situation where someone applies to the Office of the Public Guardian to petition for guardianship over the person with the disability. It's important to understand that guardianship is not like a blank check that you can do whatever you want over the person with a disability. There are some specific decision-making items that you can't make without court approval. They're listed on the slide, and you can probably understand why the court would want additional oversight here. So there are things that have really significant financial impact, like making a will. We don't want people becoming guardian over somebody with significant money and as a way to gift it to themselves, for example. So settling lawsuits, things like that. Conveying title to real property. So if the person with disability owns the house, before you can sell it or transfer it to somebody else, that would require court approval. And then the last two are pretty significant in terms of the personal rights of the person with the disability. Is you can't consent for the person with the disability to be sterilized without court approval. So that would be taking away their ability to have children in the future, or involuntarily commit the person to an institution. And that last one is often something that people seek guardianship for. So it's important to understand that you would have to additionally seek court approval for that last step of seeking to institutionalize somebody. Okay, so once a guardianship is put in place, the guardianship lasts until the person who's subjected to the guardianship dies, or until the court otherwise terminates it. So the court isn't going to, on its own, move to terminate a guardianship. It requires somebody to file an objection. So somebody involved, it could be potentially the ward, or it could be another interested person, would have to move to terminate the guardianship. And as you're probably aware from recent current events involving some celebrities, it can sometimes be really challenging to terminate a guardianship once it's put in place. So it's something we really encourage people to think long and hard about before putting in place. Once the guardianship is there, it can be hard to get out from under it.
So one of our special topics regarding guardianship, of course, is voting. So there is the misconception that individuals who have guardianship over them aren't able to vote. And that is not true. So having a guardianship does not affect the right of an individual with a disability to vote unless there is a specific, unless it's specifically written in the guardianship that that individual cannot vote. And there's only one person that can make that decision, and it's a judge.
Thank you. And I see we have a couple questions in the chat and the Q&A, so I just going to pause for a second so we can see those.
Sure.
Will these slides be available after the presentation? We can share them with NAMI afterwards, yes. Yeah, so one of the questions is, can you give an example of limited guardianship? So it could be maybe somebody has very specific financial resource or asset. Maybe they inherited some money. Maybe the guardianship is really limited to the decision making of that resource. Would be one example of a limited guardianship. So it's just, instead of kind of globally saying the person with a disability cannot make any financial decisions, it's just narrowing in on one set of decisions that you're concerned about and putting in place protections for that. Okay. All right, so with guardianship, there are pros and cons to pursuing this avenue. One pro, of course, is that it offers the person with the disability protection by having somebody else make some of the decisions that would otherwise, the concern is that the person with the disability would be otherwise at risk or not be safe. It can be more convenient to have the authority to apply for public benefits, handle financial affairs, interact with disability service agencies and other government entities. It also provides the guardian some protection and it protects the ward as well, some protection. So for example, the ward can't, once the guardianship of the property is in place, the guardian can't enter into the ward can't enter into a contract. So the guardian would be able to void a contract, for example, in that kind of situation. The cons are, there's a lot of red tape. It's, as we alluded to earlier, a complicated process to go through the court procedure. You have to notify anyone who might be interested in the proceedings. You have to get consent from any attorneys that previously represented the ward. There's a lot of paperwork. It's not fun. It can be unnecessary. So a lot of times people are told by the schools or by the doctor's office, oh, you have to get guardianship to be able to do that, when it's not true. And we're going to talk about that in a few minutes. So you really want to know that it is actually necessary to protect yourself or your loved one before going through with guardianship. Guardianship can be an instrument of abuse. It gives a lot of power over another person. So there are lots of people that pursue guardianship who only want to pursue the best interest and welfare of the person with the disability, but there are some that are not proceeding from goodwill, that they are doing it as a way to control the person, as a way to get access to their resources, as a way to further abuse the person. And it's very concerning and very hard to get out of in that situation. It's also very disempowering. So instead of building a person up and focusing on strengths, the process really focuses on their weaknesses, and it doesn't allow growth, which is contrary. All of the research in terms of supporting people with behavioral health disabilities and having positive behavior supports really tell us to build people up, focus on their positives, and guardianship really does the opposite. So it's important to understand that before proceeding with one. So big picture, guardianship takes away the rights of the person with the disability and gives it to another person, the guardian. It really puts the person with the disability in the position of being a child, subject to their parents' authority. Everything else that we're going to talk about today is about delegating, the person with the disability delegating their rights to somebody else. So it's much more empowering because they're involved in the process. So we're going to talk about some alternatives to guardianship in just a moment. And we just want to acknowledge as we go into this, there are a lot of situations where there may be other options. There are some situations where guardianship may be the only option. And so we just encourage you to consider and go through the process of looking at whether any of the other options would work in your situation, because guardianship, while it may be the best situation for your family, it's a very drastic situation. So you want to know that you considered everything before you go to that. Jackie?
Thank you. So as Marissa mentioned, we're going to talk about a few different alternatives to guardianship. There is a wide spectrum of them. We're going to hit on a few, including Social Security, representative, supportive decision-making, power of attorney, advanced healthcare directive, healthcare surrogacy. We're going to start off the conversation with supportive decision-making. So supportive decision-making is actually one of those decision-making alternatives in which the individual themselves functions very independently. So without using a guardianship or delegating decision-making authority to someone else. So basically what it is that the individual person with a disability will ask someone, whether it be a family member, a friend, or whoever it might be, to assist them with decision-making. And part of what they will help them with is, health affairs, supportive services, financial affairs. So just to give a brief example, so for health affairs, a supportive decision maker would be able to access the individual's health records and be able to gather information on any health decision that an individual needs to make. So that's kind of what a supportive decision-making agreement would look like. And it is an agreement. It requires the individual to have capacity to be able to name someone as their supportive decision maker. And it requires 2 witnesses present at the time of when the individual is signing. And just like all the other alternatives that we're going to discuss today, you want to make sure that the individuals that are being supporters, that are being agents, that are helping the individual with disabilities are trustworthy and that will act in the individual's best interest. And I'll repeat this as we go through, but please know that any of these options, you can always revoke any of these agreements, including the supportive decision making agreement and all the other documents that we're going to discuss. Okay, so now we will move over to the durable power of attorney. This is widely recognized. I think a lot of people know the power of attorney more than supportive decision making. So the power of attorney requires an individual to have capacity to appoint an agent to act on their behalf. So this is a shift from the supportive decision making in which the person is choosing someone to be able to act on their behalf without stripping themselves from power. So the individual with disability will continue to be able to make decisions. It's just they're assigning someone else to also be able to make those decisions. And one quick thing to note is that the power of attorneys are not for healthcare related decisions. There are a few components that we'll discuss in the next slide that do apply to health. But in terms of the power of attorney, it could take effect. So there's the springing versus non-springing, and it's just fancy terminology as to when the document will take effect. So springing means the POA will take effect when the individual loses capacity and isn't able to make their own decision. So it'll spring into action. And non-springing means that the POA will take effect immediately upon the individual signing it. And similarly to the supported decision-making, it could be revoked at any time. And just to remember that the POA is very financially driven. There are a few aspects like insurance components, state agencies, disability organization, kind of components in there, but it's very heavily financially driven.
So often in the powers of attorney that we do for our clients, we'll include language around ability to interact with disability service providers to coordinate care, just to really help, because oftentimes family members kind of serve as like an informal case manager, if you will, for the individuals with disability, and just to make it clear that that's authorized by the person with the disability and consented to.
Okay. And so POA is definitely a very effective tool. And similarly to what Marissa had mentioned in the guardianship, the agents have a fiduciary duty to act in the individual's best interest. That being said, because it's very financially driven, and because the individual gets to act on behalf of the person with disabilities, there is a risk of abuse. And this is definitely a conversation that we have with the individual when they come to our office. And it involves a conversation of, do you trust your agents, or who you want to designate as your agents?
Wrong way.
Okay. Okay, so advanced healthcare directives, these are health related. So it's actually a hybrid document between a living will and a healthcare power of attorney. So it not only allows you to appoint an individual to make healthcare decisions when the individual with disabilities becomes incapacitated, but it also allows the individual with disabilities to be able to express instructions on, it also includes any special instructions for their family members or their agents, whether they like to donate organs. And they also can provide permission for agents to be able to sign or vote a DMOS form. So this one is specifically health related. And similarly to the POA and the supportive decision making, an individual must be competent when they're creating this document. And the advanced healthcare directive will only go into effect if an individual is that lacks capacity and it's deemed by his physician to lack capacity. So this isn't one where an individual can choose, oh, I want it to take effect when it's upon signature. It just doesn't work that way. Okay. So once again, only when the primary physician determines that the individual lacks capacity will it go into effect. And capacity in this context, I'm sorry, is the individual's ability to understand the risks and benefits to their healthcare. So this requires a different capacity than you would for like the POA and the supportive decision-making agreement. I'm sorry, I kind of lost myself in there. So the individual with disabilities is in control of their healthcare decisions until they're deemed to lack capacity. So even if you make the advanced healthcare directive, sign it and store it away, the agents that the individual selects would not come into play, and the document itself would not come into play until a physician says this individual lacks capacity.
Jackie. Right, I'm going to talk about a not very well-known decision-making tool that's available in Delaware. That is one of my favorites because you do not need a lawyer to do it. It's called healthcare surrogacy. I think healthcare decision-making is probably one of the most common reasons we hear from people as the reason they seek seeking guardianship over their family member with a disability. And they generally are unaware of the healthcare surrogacy statute. And a lot of healthcare providers are not aware of the healthcare surrogacy statute. So what the healthcare surrogacy statute is that it allows for someone other than the patient, the individual with the disability, to be designated as the decision maker for healthcare decisions. If the person with the disability has capacity, they can actually designate someone to be their healthcare surrogate. So, they can say, I want you to treat my mom as my healthcare surrogate. And then mom gets to kind of stand in that person's shoes and get access to health information and be able to make decisions. There's no special legal form that has to be done. It's something that is recorded by the primary care physician and witnessed by someone other than the person that's going to be the decision maker. If the person with the disability does not have capacity, then the primary care physician can make a determination that they lack capacity for healthcare decision making. And then they designate a family member under the surrogacy statute to serve as the healthcare surrogate. And the statute has a list of family members who are eligible to be designated. And it's in an order of priority. So the first priority is a spouse, unless there's a divorce pending, an adult child parent, and then so on the list. So one exception would be if there's protection from abuse proceedings between the patient and the potential surrogate, that would disqualify them. So this, again, is just something that the physician can do in the medical record with a witness. And you have the ability to make medical decisions without having to go to court in the guardianship process. So it's really a really helpful tool for families that do have medically needy family members that have disabilities that are either unable to make their own decisions or need support to make decisions. Oops. The decision making that healthcare surrogates have is just as broad as those that are exercised under an advanced healthcare directive. And they have the same rights to access health information under HIPAA. So that's an important thing to know. The limitation on healthcare surrogacy is that it only applies to health decision-making. So it is not for other contexts. You cannot assert yourself as a healthcare surrogate under the statute at the bank. So, but like I said, it can be really useful for families that are needing to make medical decisions when there isn't another decision-making process in place. Health surrogates also come into place when an advanced healthcare directive exists, but isn't clear or doesn't cover a decision that needs to be made. So sometimes there's an interplay between the two, the healthcare surrogates and advanced healthcare directives.
Okay,
all right.
Sorry. So another alternative is a Social Security representative paid through Social Security. So this is one of those alternatives that does have a different definition of capacity. So when we speak of capacity, so the capacity is determined by Social Security, and they get a statement from the individual with disabilities doctor. And so what this representative pay basically does is manage the individual's funds. They still have a fiduciary duty in that they must responsibly handle the individual's funds. So, pay their bills and make sure that they have what they need. But it is an alternative if there is a financial concern. And there are also additional options that we really didn't go into specifics about, but we wanted to include them because we obviously did not exhaust the whole list. So there is also case and care management through different state agencies, working with community advocacy system and community agencies, establishing trust, creating joint checking accounts, although that could be used as an instrument of exploitation. So if there is another option, I would go with that. Drafting release forms, which are very, very, very effective. And it's definitely something that we always suggest when parents are calling our office. And then in terms of education, giving an educational representative a grant of authority. So allowing, if you have a youth that has an IEP, having them be able to assign someone to be kind of their voice and speak on their behalf when it comes to their education.
Yeah, and just more on that last piece. So there is a process under Delaware law and regulation that's to take place when a child is approaching the transition to 18. So it's usually, I believe it's the IEP where they're turning 17. The school has to go through an analysis, the IEP team with the parent and the student, about whether or not the student has capacity to make educational decisions. If the student does not have capacity to make educational decisions, then the IEP team can designate, usually the parent, to be the educational representative after the student turns 18. Otherwise, the student would be the person that exercises their own rights at 18. But the student who does have capacity can choose, kind of like a power of attorney, to grant authority to someone else, like their parent, to continue to exercise their educational rights in addition to themselves. So for anyone that's on the webinar that has kids in school still, it's important to be aware that there is a process the school should be going through with the IEP team, if there's an IEP, to make that determination for school services. The IEP should also include transition portion. And in that transition section, you can work with the IEP team to talk around some of these issues with decision making. So for example, you might want to advocate for your student to have goals around making good decisions, maybe the ability to say no. Maybe they have a hard time saying no, and that's why you're concerned. So maybe that's something that the IEP team can work on them with and create an actual goal toward that. So that's something to think about. And like Jackie said, release forms can work really well. You just keep them current with the treating provider so you can continue to communicate with your child's provider after they turn 18, assuming that's what your child wants you to do. So just kind of summing up, what are my specific fears and concerns? We really encourage you to think about, what are you worried about? What decisions are you afraid that the person with a disability, or if you're the person, that you need help with? So identify those and then think about what tool you need to address them. So if you're concerned about finances, think about, would serving as having a representative payee, having a power of attorney, establishing a trust that has limitations on what money can be pulled out and for what, using a joint bank account, is this adequate to address the concerns about managing finances? If your concern is about healthcare, can you get what you need through release forms, through an advanced healthcare directive, or through healthcare surrogacy? Case management services can be really helpful in supporting a person with a disability in decision making. Also, for both categories, supported decision making. So that's, again, having committed supporters who help gather information that the person with a disability needs to make a decision, can present it to them and their options, and really help support them and encourage them to make good choices. So these are all options that may address what your concerns are, may address what your fears are. And ask yourself, can my fears and concerns be addressed without seeking legal guardianship? If yes, then there's no reason to seek guardianship. If the answer is no, then at least you know you did your due diligence and really explored all the options and considered them. So that is our content of the presentation, is a very quick overview of some of the options, just to really give you an introduction to what is out there for you to start thinking about if you're looking ahead to some of these decisions or if you're facing them now. Our office, as Jackie mentioned at the beginning of the presentation, does not handle guardianship. So we represent people with disabilities, but we do help people with alternatives to guardianship. So if the situation is one where a supported decision-making, power of attorney, or advanced healthcare directive would be appropriate, you're welcome to contact us to apply for legal assistance. We do have offices in each county, which is maybe a little less relevant at the moment, that most things are remote, but in regular times, we do have an office location in each county for our clients. We can take questions, and I also just want to note in the chat, as well as on the PowerPoint, is our survey for basically feedback on the presentation, if you'd like to provide it.